Prior to pleading, the court satisfied itself that the accused fully understood the nature of the charges as well as the minimum sentence legislation and the implications thereof. On 15 August 2025, the accused pleaded guilty to all counts as charged. See Exhibit A. Further exhibits were handed in by consent. These include Exhibit B, the post-mortem report relating to Count 2, Exhibit C being an affidavit of an official from the Department of Home Affairs relating to Count 4, and Exhibit D, photographs of the crime scene being the accused's shack where counts 2 and 3 were committed and where the body of the deceased was discovered. The court then convicted the accused as charged on all counts. Exhibit E was then handed in, being the SAP 69 of the accused, which reflects that he has no previous convictions. By agreement, the matter was then postponed for sentencing proceedings. On 19 August 2025, counsel for the accused addressed the court in mitigation of sentence. The accused did not testify and no witnesses were called. His personal circumstances are as follows. His birth date is 1 April 2000. He was accordingly 24 years of age at the time of the commission of the offences. He has a matric level of education and thereafter trained to be a welder and was self-employed as such at the time of the commission of the offences. He is married and has a child aged 1 year and 3 months. It was submitted that he demonstrated remorse in pleading guilty. He is a first offender. He was arrested 2 days after the commission of the offences on counts 1, 2 and 3 and has been in custody since. The state called the mother of the deceased to testify in aggravation of sentence. and further submitted her victim impact statement marked Exhibit F. All of her evidence is on record, and the court does not intend to burden this judgment unduly by reiterating same. In short, she gave a heart-rending account of the effects the murder of the deceased have had and continue to have on her and the younger 3 of her 4 other children. It was ironic that the day she testified would have been the deceased's 7th birthday. She has, as a result, become angry and agitated and has developed a hatred towards foreigners. The 3 younger children were stopped from attending counselling as they were not participating in or expressing themselves at these sessions. She herself had also stopped counselling as she had recently become employed and would become upset at work. She has stopped taking the children to Sunday school and she finds it difficult to go to church and to pray. She was forced to seek assistance from certain stakeholders to pay for the costs of the deceased's funeral. She desires that he receive multiple life sentences. The deceased was her youngest child, 6 years of age at the time of the commission of the offences. She described the deceased as a lively, high-spirited child who would dance and have animated conversations with herself in English while standing in front of the mirror. The court encouraged her then, as it does now, to resume with the counselling in respect of herself and her children, and that she and her children go back to church. This is not to forget the deceased, but to enable them to live with their devastating loss. There was no cross-examination of this witness. The state submitted that the court impose 5 years imprisonment sentences on counts 1 and 4 and life imprisonment on counts 2 and 3. In determining an appropriate sentence, it is trite that the court is required to consider the personal circumstances of the accused, the nature of the crimes and circumstances surrounding the commission thereof, and the interests of the community and society at large. It is further essential that the purposes and objectives of punishment be considered, namely namely deterrence, rehabilitation, retribution, and prevention. The imposition of sentence is the most difficult task for the presiding officer in trial proceedings. This court has spent much time considering the sentences to be imposed. In so doing, the court has borne in mind the various principles contained in our case law, inter alia. That the punishment must fit the criminal and the crime and be blended with the measure of mercy. That a message must be sent to the community that offences will not be dealt with too leniently so as to bring the judicial system into disrepute. That the offender must not be punished to the point of being broken, and that the sentence not operate as a sledgehammer. That all the mitigating and aggravating factors be considered in arriving at an appropriate sentence. The accused was convicted on counts 2 and 3 in terms of the minimum sentence legislation as charged. Regarding the murder on count 2, this was on 3 grounds, namely, Part 1, bracket, small a, close bracket, where the murder is planned or premeditated, the accused having killed her after raping her in order to conceal his wrongdoing as stated in his plea. Secondly, part 1, bracket small b, close bracket, open bracket, 2, close bracket, where the murder victim was under the age of 18. And thirdly, part 1, open bracket C, close bracket, open bracket 1, close bracket, where the death of the victim was caused by the accused, in this case after having committed the offence of rape. Regarding the rape on count 3, part 1, open bracket, B, close bracket, open bracket 1, close bracket, where the victim is a minor. The accused was at all material times and prior to pleading made fully aware that he faced a minimum sentence of life imprisonment on each of these counts. In terms of this legislation, it is mandatory for the court to impose the prescribed sentences unless the court finds substantial and compelling circumstances to exist. Whilst this court has a discretion in that regard, that discretion must be exercised properly and judicially. In determining whether substantial and compelling circumstances exist, this court is guided by the decisions of other courts and is bound by the decisions of the superior courts. The locus classicus on this issue is the decision of the State versus Malchus, 2001, Volume 1, South African Criminal Reports, page 469, a decision of the Supreme Court of Appeal. This decision was, however, decided over 20 years ago and has, over the years, been elaborated upon, amplified and supplemented by the superior courts. This court is required to determine whether the mitigating factors, either individually or cumulatively considered, constitute substantial and compelling circumstances looking at the facts and circumstances of the case as a whole.
ika xiyimo ku va yi kombeliwa court ku loko yi endzela xiyimo xa vutomi bya wena makulelo ya wena ku dyondza ku fikela kwihi hambiloko ho teka hi ndzimana yin'we kumbe swi hlanganisa hinkwaswo swi nga va swi ri koho swi hlanganisa ka xiyimo xo karhi lexi kumekaka xi ri na matimba swa ku hi ku ya hi nandzu lowu a maendlelo ya wena leswi nga swi endlisa swo vubihi swa ku va koteka ku va nga ku ololoxela xikwembu kumbe njhani.
Further, if this court is of the view that the imposition of the minimum sentence would be disproportionate in considering the facts and circumstances as a whole and result in an injustice, then the court is entitled to impose a lesser sentence.
Kambe loko se yi xiyaxiya yi kota ku lavisisa nandzu loyi vona ku loko yo teka ka xiyimo xa wena matshamelo ya wena vumunhu bya wena yi ve yi ku yona ku fanekela ku yi ku nyika xilo lexi nga boha yikulu yi ku nyika nga fanekela yi ta va na yi joyina nawu kambe loko nawu u kombisa swo fanela ku endla swoswo a yo fanekela ku va loko swi nga ri na matimba swiyimo leswi swi fikaka yi kota ku kombisa.
The above decision states that in enacting the minimum sentence legislation, and I quote, the legislature aimed at ensuring a severe, standardized and consistent response from the courts to the commission of such crimes. Unless there were and could be seen to be truly convincing reasons for a different response, ... unquote. Furthermore, and I quote, that the specified sentences are not to be departed from lightly or for flimsy reasons which cannot withstand scrutiny, ... unquote. This has been reiterated by the Supreme Court of Appeal over the years on numerous occasions. The court has considered the mitigating factors. It is trite that the fact that an accused is a first offender does not on its own constitute a substantial and compelling factor. He has been incarcerated for just over 10 months awaiting finalization of the matter. This is a relatively short period of time. The probabilities are that had the accused indicated his desire to plead guilty immediately upon his arrest, the trial may well have commenced earlier. Whilst he is relatively youthful, the fact that he was 24 years of age when he committed these offences and that he has a matric education and the viciousness of his deeds rule out any immaturity. The fact that he will be apart from his wife and child for many years to come are a direct result of his own wrongdoing.
xivangelo xa ku u ta va u hambane na n'wana wa wena ni nsati wa wena hi malembe ya ku tala ngopfu leswo swi ya hi mihandzu ya mintirho ya wena.
There is no evidence whatsoever as to the volume of alcohol the accused had consumed on the day in question.
A ku na vumbhoni lebyi byi teki swa ku leswi wena a wu nwe byala hi siku rolero u nga endlekile lebyi a wu nwe byala u kota ku fikela kwini.
Whether he had also committed, I'll repeat that, whether he had also consumed the beer he had purchased after he had committed count 1.
Na ku va loko u ta va u teki n'wana loyi a xitaratini leswi nga ku u ya xava biya a hi zanga hi twile swa ku biya leri u hetele hi ku va u ri nwile kumbe u nga ri nwanga.
And that this had in any manner had any effect on him in the commission of the offences.
Kumbe ku nga ta va ku ve na muchelela muni ka ku va loko u ta va u ri nwile ri nga ta va ri rona ri nga va ri ku endlisa exiswini a na vumbhoni lebyi byo swa ku fambiseka.
It was submitted that in pleading guilty he has demonstrated remorse. In paragraph 22 of his plea, he states that he regrets his deeds, apologizes, and begs the court to have mercy on him. In the matter of State versus Machichi, 2011, Volume 1, South African Criminal Reports, page 40, a decision of the Supreme Court of Appeal, it was stated that a plea of guilty in the face of an open and shut case against an accused is a neutral factor. Further, that there is a chasm between regret and remorse. Whether the offender is sincerely remorseful and not simply feeling sorry for himself at having been caught is a factual question. It is to the surrounding actions of the accused rather than what he says in court that one should look at. Before a court can find that an accused is genuinely remorseful, it needs to have a proper appreciation of inter alia, what motivated the accused to commit the deed, what has since provoked his change of heart, whether he does indeed have a true appreciation of the consequences of those actions. In the current matter, there is no indication or evidence of this, and the accused failed to testify thereto. His failure to testify further leaves many unanswered questions inter alia. How did he keep the victim hostage while he went to purchase a beer? How long was she kept hostage before he raped her? How long did the rape endure? How long after the rape did he murder her? What is evident is that the body of the deceased was found on the floor of his shack and that he had fled after the commission of counts 1, 2 and 3 and was subsequently arrested after 2 days.
Leswi swi nga kona hi swi tivaka hikuva ntsumbu wa n'wana lowu kumeke na u papala hansi laha mukhomi wa wena yi veke loko wena swo hetile ku va u n'wi pfinyile na ku u ta n'wi dlaya u hetile ku va u tsutsuma u siya laha lava nga va vuya va ku khoma ndzhaku ka masiku mangari na u hetile vubihi lebyi.
There is no evidence that the accused unilaterally and voluntarily handed himself in to the authorities after having committed the offences.
A byi kona umbhoni laha mahlweni ka khoto byi hlaka swa ku wena hi ku titwa hi xiwe u fambisile u ya tinyikela u nga rhumiwa kumbe u nga sindzisiwanga u ya tinyikela hi xiwe emaphoriseni.
There is further no evidence that immediately upon his arrest he acknowledged having committed the offences.
Umsi a hi na umbhoni byi vulaka swa ku loko u ta va hi ta khomiwa hi maphorisa lowu pfumela u hlaya swa ku kunene ni nadzile loko ni yini na ntima.
In fact, and ex facie the pre-trial minute in the court file conducted on 27 May 2025, it is reflected that the accused will plead not guilty to all counts.
Nkama lowu a ku endliwa malunghiselela ya ku nandzu lowu ta kota ku tekiwa kumbe wu vulavuriwa leswi nga tsariwa ka maphepha hi siku ra 2025 nga lembe leri u tewe a minandzu leyi wa yi kaneta a wu yi tivi.
In light of all of the aforegoing, the court finds that the accused failed to demonstrate true or genuine remorse.
Ku ya hi leswi nga swi vulavula khoti kuma swa ku wena a wu kombetanga ntiyiso swa ku u ti vona nandzu u titwe na vutivi leswi nga ku endla swi nga fanekanga a wu tisoli hi ku huma mbilwini ka wena.
There are various aggravating factors.
Leswi endlaka nandzu lowu biha swi tele ngopfu.
The victim was a defenseless and innocent 6-year-old child playing in the street when she was pulled by the accused into his shack.
Yena mufi eka nandzu loyi i munhu loyi a nga tiviki nchumu i n'wana lowuntsongo loyi a nga koti na ku tilwela loyi a ri ku titlangeleni exitaratweni nkarhi lowu nga n'wi khoma hi wona u n'wi kokela ku n'wi khoma wa wena.
One can only imagine her terror at first being abducted.
Hi nga ha ehleketa swa ku xa ku sungula a chuhi ku fika ndzhakini nkarhi lowu nga n'wi khoma hi wena u ka u n'wi teka hi matimba ku n'wi khoma i ncini leswi a ti twise ku i ku chuha mina nga va na kona n'wana.
Her confusion at having her clothing removed,
Na ku va se a hlangahlangane ku fika ndzhakini enhlokweni ya yena na nkarhi lowu se wena a wu n'wi hlula swiambalo swa yena hi ku tirhisa matimba.
and her pain at having an erect male penis penetrate her vagina.
Ku vava loko a nga kutwa loko xirho xa wena xa xinuna lexi a xi pfukile hi matimba ni ku tirhisa nkani xi va xi nghena eka xirho xa yena xa xisati.
The post-mortem report evidences the trauma to her genitalia.
Loko vahlahli va ntsumbu wa yena va vona swa ku eka xirho xa yena xa xisati a ve a vaviseka hi leswi ku nga swi endla eka yena.
The accused satisfied his perverted lust on a child, the most innocent and vulnerable member of society.
Wena u tirhise vuhari lebyi nga kota ku ti hanyisa ku ya hi ku navela ka vubihi bya mbilu ya wena u kota ku va u endla leswi nga swi endleka pfuneka wena ka n'wana wa ku a nga koti ku ti vulavulela kumbe ku tivela wa ku a nga ri na matimba a nga ri na lexi a ta xi endla ku ku sivela ku nga feli.
Finally, her terror at having the accused place his hands around her neck and choke the very breath of life out of her.
Xo hetelela vubihi lebyi nga byi endla bya ku teka mavoko ya wena u n'wi kama nkolo u n'wi tiyisa ku nga koti na ku hefemula i mafele ya ku biha ngopfu hi ndlela nga yizeli wena nga fani wona.
Our society is sick and tired of this epidemic of violence against women and children that has engulfed our country.
Kunenenene vaakatiko ni ntshungu hinkwawo a va xundzuke ngopfu hi maendlela ku nga hi leswi nga dyondzisa swona i nga mavabyi lava ma hetaka tiko ra hina a va ha lana ku nchumu hi swona.
Our society is further sick and tired of the alarming frequency of the rape of children.
Funtsi vanhu se va karhele hi ku twa swa ku mhaka leyi yi ndlandlamukela ku ya mahlweni ya ku siku rin'wana na rin'wana va phameriwa mahungu ya ku ku ni n'wana loyi a nga pfumeleriwa xihlangi lexitsongo.
The accused is clearly a danger to society.
wena swa tikomba swa ku i khombo ngopfu swinene eka vanhu.
On count 1, the kidnapping, the state submitted that the court impose a 5-year sentence.
Ka nandzu wa ku sungula lowu wa ku wa teka n'wana ku mi hambanisa mintshunxeko wa wena vuchuchisi byi kombetsa ku wena va ku nyiketa xikwembu xa ntlhanu wa malembe.
The court is of the view that this is excessive for the following reasons.
Court yi vona leswaku yi nga va na swi hindzise ngopfu hi xivangelo lexi landzelaka.
This is the minimum sentence for such an offence in circumstances where a firearm is used, which is not the case in this matter.
Ku fanelaka ku va loko teka munhu mi hambanisa na ntshunxeko wa wena u nga nyikiwa ntlhanu wa malembe loko nkarhi lowu a wu mi teka u lo tirhisa xibamu ku mi xavisela hi xona leswi swi hambanaka na nandzu laha u zanga mi kombeke xibamu n'wana.
Furthermore, it is clear that the intention in respect of the kidnapping was to commit the rape.
Funze swa tikomba ku xikongomelo xa ku va u za u n'wi thyakisa kumbe ku teka ku mi hambanisa na ntshunxeko wa yena a wu endlela ku ya kota ku mi pfinya.
It is further apparent that the victim was not held hostage for an extended or protracted period of time.
Xin'wanyana kambe xa komba swa ku leswi u nga ya mi pfalela mukhukhwini a wu zanga u mi pfalele hi nkarhi wa ku leha swinene.
The court finds that there are no substantial and compelling factors warranting a departure from the prescribed minimum sentences on counts 2 and 3.
Yi hetelela court yi kuma swa ku a ku na xiyimo kumbe matshamelo lama nga na matimba ma nga kotaka ku ma tshikelela court ku va yi ololoxa xigwevo hi ku ya hi nandzu luya wa vumbirhi i nga wa ku dlaya ni nandzu lowu wa vunharhu ka wa ku pfinya.
The court position of the justice.
Kambe yi kuma swa ku court loko yo tirhisa xigwevo lexi nga vekiwa endlwini laha ku dleliwaka kona yi ta va leswi swi fambelanaka na nawu yi ta va yi nga hoxelanga nawu yi ta va yi nga hizanga yi endle leswi hambanaka na nawu ka kombela ku lulamisa.
On count 4, counsel for the state had submitted that the Immigration Act had been amended to extend the period of imprisonment to 5 years.
Kasi laha ka ku va hi vulavula hi nandzu wa munhu va ku nghenela tikweni no tshama na u nga ri na maphepha u nga ri na matimfanelo a va kombela leswaku na kokwalani u nga nyikiwa ku va u nyikiwa ntlhanu wa malembe ya xikwembu xa kona.
The court had requested proof of same, and in an email to my registrar, they acknowledged that there had been no such amendment and that the maximum period had remained a period of 2 years imprisonment.
A court yi kombela leswaku leswi va ngo ku lunghisiwile ku cinciwa nawu lowu a wu rhumela ka register va swi vona leswaku wu tirhile nawu lowu wuntshwa wu nga cinca mhaka leyi va rhumela leswaku a va ha swi kumanga laha swi nga cinca kona hikokwalaho a xigwevo lexi fanelaka ku va i ra xona xa ku kumeka ni u tshamela tikweni u nga ri na timfanelo xi ta tshama na xi yime ka malembe mambirhi.
Finally, the court wishes to briefly address the issue of the accused's unlawful presence in the Republic. The accused was unlawfully in the country at the time he committed counts 1, 2, and 3. The victim's mother testified that she has developed a hatred towards foreigners. Whilst this is understandable in the circumstances, one must bear in mind that of the many foreigners that we have in our country, and even those that are here unlawfully, many are good and hard-working people who are simply here to seek a better life. The horrific crimes that the accused chose to perpetrate has no bearing on foreigners from his country or from other countries. And irrespective of whether they are lawfully in South Africa or not. Having regard to all of the aforegoing, this court is of the view that the following are proper and just sentences in the circumstances. On count 1, the kidnapping of the minor child, you are sentenced to 2 years imprisonment. On count 2, the murder of the minor child, you are sentenced to life imprisonment. On count 3, the rape of the minor child, you are sentenced to life imprisonment. On count 4, contravening the Immigration Act by remaining unlawfully in the Republic of South Africa, you are sentenced to 2 years imprisonment. By operation of the law, all sentences imposed run concurrently with a life sentence. For what it is worth, then, the sentences on counts 1, 3, and 4 are to run concurrently with the sentence on count 2. Accordingly, the effective sentence is life imprisonment. Finally, the court wishes to thank all counsel for their assistance in this matter. Mr. Masindi, are there any applications at this stage? Thank you.
Thank you, Madam. No application.
Thank you, counsel. Thank you to the court staff. The court adjourns.
Thank you.